So, next. An accused has a right to a speedy, impartial, and public trial. This is a component of due process, di ba? We already talked about the cold neutrality of an impartial judge. So, we already know what impartial means. So, let's just talk about speedy. Lalo na in the Philippines, di ba? Speedy in the Philippines. Let's look at some of the cases. In Valencia versus Sandigan Bayan, they criminal case, of course, Sandigan Bayan, they entered into a stipulation of facts during pre-trial. Okay? But only the counsel of the accused signed. Okay? So, when the prosecution was about to wrap up their case, they suddenly realized, teka lang, one essential fact, which is in the stipulation of facts, has not yet been proven. They did not prove it precisely because there was already a stipulation. Okay? But they saw the defect being hindi nakapirma sa pre-trial order yung accused, which means the stipulation does not bind him. So when they realized that the prosecution, instead of closing their case and submitting it, asked for more time, no, to present more evidence. So the accused objected and claimed it is a violation of his right to speedy trial. So here the Supreme Court said, speedy trial, the right to speed, when we talk about speedy trial, it is not just about the time. Not just about the time. Okay? It is not mere speed, but it must be orderly and expeditious. Right? And the right to speedy trial cannot mean depriving the prosecution of its right to due process. Due process, available din yan sa prosecution, hindi lang naman sa accused. Okay? So sabi ng Supreme Court, speedy trial, the right to a speedy trial does not mean mere speed, but orderly and expeditious trial. Which in the Philippines means, when you are charged with a crime punishable with imprisonment for 6 months, it will take the court 4 years to reach a decision. Speedy. Speedy. Ganun talaga yun. No? Now, in Soriano versus Angeles, ito naman talking about impartiality. May nag-away dito. This is not an assigned case. No? May nag-away dito. Police at saka barangay captain. Magkaiba yung kwento nila. Kwento ni barangay captain, pumasok daw si police sa office niya sa barangay, tinutukan daw siya ng baril at pinagsusuntok siya in front of 4 na barangay tanod. Okay? Ang kwento naman ni police, si barangay captain, hinuli yung isang pamangkin ni police dahil may mga menor de edad na nag-iinuman. Okay. While in the barangay, nagsuka daw yung bata, so dinala sa ospital. Dumating si police kasi pamangkin niya nga, tinatanong niya, nasan yung pamangkin niya, binabastos daw siya ni kapitan, kaya nagkaroon sila ng altercation. Okay, so dalawang magkaibang kwento. During pre-trial, sinabi ni judge, oh, kapitan, police, baka naman pwede kayong mag-usap na lang. Ayaw ni kapitan. Okay. Start ng trial, sinabi na naman ni judge, talaga bang hindi kayo pwedeng mag-usap? O kailangan ba bigyan ko kayo ng cooling off period para mag-usap kayo? Ayaw ni kapitan. Okay. Present ng evidence. Now, nag-present ng evidence, hindi nag-offer. Ito kasalanan ng abogado ni kapitan. He presented witnesses but he never offered the testimony. You will later learn in your law school journey, no, that evidence not offered cannot be admitted. Okay? Hindi ka nag-offer. If it was not formally offered in evidence, it cannot be admitted. Therefore, it cannot be considered in the decision. So, the court, in its decision, acquitted the policeman. Certiorari ngayon si kapitan kasi acquittal eh. So, nag-attach na yung jeopardy. He cannot be tried again for the same offense. So he went on 65 saying the court acted in grave abuse of discretion, thereby losing its jurisdiction, kaya walang double jeopardy. So the Supreme Court said, number one, ang basis mo ng partiality is the fact that the judge was encouraging settlement. Sabi ng Supreme Court, that's not partiality because all judges must, if they feel there is a possibility for settlement, that they should exert all efforts to push the parties to settlement. That's not impartiality, that's performance of duty. What about yung to admit or not to admit the testimony of two witnesses kasi? The complainant himself and the kagawad who was supposedly present nung sinapak-sapak siya. Sabi kasi ni Kapitan, Barangay Kapitan, mali si judge for saying it is inadmissible because it was not offered. Because it is true, it was not offered. Their lawyer forgot to offer it. But he was cross-examined. Okay? So if he was cross-examined, may waiver ng failure to offer. Tama din si Kapitan doon. No? But the Supreme Court said, well, that error is not an error of jurisdiction. That is an error of judgment. Besides, sabi ng Supreme Court, if you look at the records of the case, though the court said the testimony of the Kapitan and the kagawad were inadmissible, if you read the decision, she, in fact, cited the testimonies of those two. So while claiming it to be inadmissible, she actually cited the testimonies of the two witnesses, thereby proof that she did not really not consider their evidence. So sabi ng Supreme Court, there was no impartiality in this case. Okay? Walang impartiality. Because the court decided properly, considered the evidence before rendering a decision. In the case of the Ampatuan trial, no? Siyempre, alam niyo naman itong si Ampatuan, yung massacre ng mga media men, di ba? Such a big media event. So, the media, news organizations want to cover the trial live. And they were invoking this right, the right to a speedy, impartial, and public trial. So, sabi nila, dapat payagan yung mga newsmen to cover it because the Constitution says public trial. And the Supreme Court, in this case, had the opportunity to explain. Correct, nakalagay sa Constitution yan, public trial. But the right does not belong to the media, nor does it belong to the prosecution. The right belongs to the accused. No? Here, the Supreme Court explained, why do you have that right? You have the right to a public trial so that the state cannot conduct secret trials where no one knows what the evidence was and why you were convicted. Okay? But sabi ng Supreme Court, a public trial is different from a publicized trial. As we already learned in Maxwell versus Shepard, diba? A publicized trial can in fact lead to deprivation of due process to the accused. So the Supreme Court here clarified na you cannot invoke public trial to justify news coverage. Nonetheless, the Supreme Court said, well, yeah, it is a matter that is a concern of the public, and therefore the media may cover it, pero under certain rules to be dictated by the court. Because public trial, the right to begin with belongs to the accused. Second, a public trial is different from a publicized trial. And we do not want a publicized trial because it will affect the due process. Okay? And then in People versus CA, Supreme Court lang explained, no, that our rules and our laws allow promulgation of judgment in absentia. The only part of criminal proceeding that is not allowed to proceed without the presence of the accused is the arraignment. Because in the arraignment, he must personally be informed of the nature and cause of accusation against him. After that, di siya sumipot, everything else can proceed in absentia, including promulgation of judgment. Right?